Hello, everyone. Welcome to today's panel on education rights and state constitutions. Thank you all so much for being here, both in person and virtually. My name is Miriam Seifter. I am a law professor at the University of Wisconsin Law School, where I also am faculty co-director of the State Democracy Research Initiative, along with Rob Yablon. The initiative is a program here at the law school that aims to foster greater research and dialogue on issues related to state courts, state constitutions, and state-level democracy across the country. I am happy to be your moderator for today's event, and we're grateful to our SDR team for making this event come together. The first thing I have the privilege of doing today is introducing our panelists, which I will do alphabetically. First, Scott Bauries is a professor of law at the University of South Carolina Joseph F. Rice School of Law, where his scholarship focuses on judicial decision-making in state and federal constitutional cases, and where his teaching has earned him a Best Classroom Teacher Award. Prior to joining the South Carolina faculty, he taught at the University of Kentucky College of Law for 14 years, and also clerked on the 11th Circuit and worked in private practice. Professor Bauries graduated first in his law school class at the University of Florida, where he also received a PhD in education. Prior to his legal career, he taught English and coached soccer for several years at the secondary school level in both public and private schools in Florida. Suzanne Eckes is here today in place of Michael Bindus of the Institute for Justice, who sends his sincere regrets and is dealing with a family emergency. Our thoughts are with him. We are fortunate to have the nation's top education school just across the hill, and we are really grateful to have another expert on education law joining us. So, Suzanne Eckes is the Susan S. Engelleiter Professor of Education Law, Policy, and Practice at the University of Wisconsin-Madison School of Education. Her scholarship focuses on how civil rights laws impact education policies in K-12 public schools, and she's the author or co-editor of several articles and books, including Legal Rights of School Leaders, Teachers, and Students. Previously, Professor Eckes was a professor at Indiana University, a lawyer, and a public school teacher. She is also a triple badger, holding her PhD from our education school, a JD from our law school, and a BA from UW-Madison. She has won many awards and distinctions for her scholarship and teaching, including, if I counted correctly, winning 12 teaching awards while at Indiana University, receiving the Martin Luther King Jr. Building Bridges Award from that university, and serving as president of the Education Law Association in 2017 and 2018. Janel George is an associate professor of law at Georgetown Law and director of the Racial Equity in Education Law and Policy Clinic there, which engages law students in lawyering work to address racial inequality in public education. Her scholarship focuses on racial stratification and inequality in U.S. education and legislative and policy interventions to address it. She has authored articles on topics including school discipline and the school-to-prison pipeline. Previously, Professor George served as senior counsel at the NAACP Legal Defense and Education Fund, as well as legislative counsel on Capitol Hill. She is a graduate of Spelman College and also received her JD from right here at the University of Wisconsin Law School, where she was also a managing editor of the Wisconsin Law Review. Finally, Preston Green is the John and Maria Neag Professor of Urban Education and Professor of Educational Leadership and Law at the University of Connecticut Neag School of Education. He is a nationally recognized expert on the legal issues surrounding charter schools, school vouchers, student rights, school desegregation, and school finance. Before arriving at UConn, Professor Green taught education law courses covering both K-12 and higher education at UMass Amherst and Penn State. He holds his Doctor of Education and JD from Columbia University and received his BA from the University of Virginia. Professor Green has written 5 books, has designed education law programs at both UConn and Penn State, and has received a Distinguished Alumni Award from Teachers College at Columbia University. Please join me in welcoming this outstanding panel. Okay, before we dive into our panel discussion, I have just a few more things to cover. First, a little bit of housekeeping. For those of us here in the room, please be aware that this panel is being live streamed. This event was approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners. We will conclude at 4:15 p.m. For those of you attending in person, if you want CLE credit, there is a CLE sign-in table just outside this room. Please make sure to stop there before leaving today if you haven't already. If you are attending virtually and want CLE credit, please listen for the passcode that I will give around 4:05 p.m. Central Time, I promise. We will provide a link to a Google form in the chat box at the same time You can complete that form with the passcode by 8 p.m. Central today to receive your CLE credit. In addition, we plan to save time to take questions from the audience at the end of the discussion. If you're here in the room, you can use the index cards that you see on the tables, and we'll have people coming around to grab those. For our virtual attendees, please use the Q&A function on Zoom, not the chat, but the Q&A, to ask your questions. Okay, second and last, before we dive in, I just want to offer some very brief remarks on our topic, which is the intersection of education and law. So, as all of you probably know, our nation's education system is primarily a product of state and local law and governance. And after the US Supreme Court's decision in San Antonio Independent School District versus Rodriguez, holding that the federal Constitution does not guarantee education rights, much of educational rights litigation also happens at the state level under state constitutions. Every state constitution contains a provision mandating a public school system, and most state constitutions also require states to provide students with an education of a certain quality. But do they? This is a rich and timely topic. Few people, it seems, would say that our nation's education system has fulfilled its potential to empower all students on equal terms. Yet there are a range of views on what the problems are and how to solve them. And both the problems and solutions tend to be intertwined with questions of state constitutional law. I will flag just a few recurring issues that will come up in our discussion today. First, what is it that state constitutions require? And who defines what it means for an education to be adequate or equal? Second, if some states and families believe that private or religious schools are part of the answer, what do state constitutions say about whether state dollars can go to private or religious schools? And how have the US Constitution and the US Supreme Court changed or superseded what state courts have held about that? And third, to what extent do state constitutions govern questions around charter schools? Can states grant charters to privately organized schools that have a religious affiliation? We are very excited that this distinguished panel is here to explore these questions with us. So I'm going to start by posing a question to each panelist in their area of expertise that will help us understand successive slices of the big picture. After that, we'll have our Q&A with questions from both me and all of you. And if you're here in person, we also invite you to stick around afterwards for a reception. Okay, so we are going to start with Professor George, then Professor Bauries, then Professor Eckes, then Professor Green. Professor George, welcome.
Thank you.
Can you give us a sort of overview of educational inequality today in the United States? What are its drivers? What are its manifestations?
Sure. Before I do that, though, I want to say, y'all, it's so surreal to be back here 20 years. Time flies, I can say that. I never imagined that I would become a law professor. I wanted to be a civil rights lawyer. I thought that would be my career. But I will say, just remain open to the possibilities because you don't know where your path will take you. So when talking about educational inequality, I think it's important to recognize, as you all are here learning about the law, that the law at times has functioned as both a way to entrench inequality and as an emancipatory tool. So take what you're learning, think about how to leverage it for good, okay? So a lot of the inequities that we'll be talking about, and some of which we just heard about, are by design. They're not inevitable. They're not organic. They didn't just happen. And the law has played a significant role in shaping those inequalities. So we'll also talk a little bit about the potential of the law, again, to eradicate a lot of these inequalities. So bear with me for a moment. I'm going to do a little bit of a history lesson, you all. And I get this is like a legal panel, especially for the CLE people. This is not a history panel. But think about when you go to the doctor's office and you're asked to fill out all those forms. What are they asking you? What kind of questions are they asking you? Medical history, right? And not just your medical history, but the history of your family. Why do you care if my grandfather had cataracts? Well, because whatever it is you think you're showing up for may not be what you think it is. History matters. History matters. And even though it seems like, oh, all that stuff was so long ago, it still has repercussions for today. So let me start with a snapshot of history, and then I'll get to the second part of the question about what is continuing to drive a lot of these different educational inequities. So when we think about the origins of this country and we think about the role of chattel slavery in this country, we have to recognize that education in many ways was weaponized to maintain that institution of slavery. There was a magazine in the 1800s that had a major headline that said that the alphabet is an abolitionist. Think about that. Education, literacy is freedom. And so in order to maintain an institution of oppression and forced labor, education had to be deprived, right, from enslaved Black people. So education was criminalized, penalized through a system of codes, first known as the slave codes and then as the Black codes. And so not only was the enslaved Black person who learned how to read or write penalized, but whoever taught them was penalized as well. And after several rebellions, including the Stono Rebellion in South Carolina and Nat Turner's Rebellion, some states made the penalty death. And so it wasn't until post-Civil War, and Derek Black, who's also at Wisconsin, writes about this in a book called Schoolhouse Burning, that we see the establishment of our contemporary public education system. Ironically, those same former, now emancipated, enslaved Black people led the charge in creating that system. So they who had been deprived of education and learning helped to go back to their home states. Many of them were elected to office during Reconstruction, very brief Reconstruction. They led the charge for passage of compulsory education laws in their home states and also helped draft state constitutional language that we just heard about, outlining the state's responsibility to provide education to everyone in that state. Education became so revered post-Civil War that it became a requirement for readmission to the Union for those last couple of holdout states to include that provision. So now all states have this education provision. There's no federal right to education. You can search the Constitution. It's not there. The case of San Antonio versus Rodriguez that was mentioned in 19, the Supreme Court said there's no implicit or explicit right to a constitutional federal right to education. And by the way, they said any kind of resource disparities that we see, those are not unconstitutional either. But again, if we go back and we look at history and we recognize the role of the law in perpetuating inequality, we can recognize why we have these educational inequities based on geography. Scholar Latoya Baldwin Clark calls these geographies of opportunity. So if you think about, for example, you all are, I don't know how many, are there 1Ls in the room? Oh, bless your hearts. Okay. This is great that you made it out here, though. This is great. So you may learn in contracts about restrictive covenants. Contracts are property. I'm in the wrong class. I don't know. Property. Thank you, Preston. I swear I teach law. You'll learn about these ways that so many Black people were denied home ownership, were denied avenues to building wealth. And if you think about, most jurisdictions fund their education through property revenue. So if you have been confined to areas, and the federal government was complicit in this as well, in redlining majority Black communities, these kind of discriminatory practices, so the restrictive covenants, which basically said you cannot sell this home to someone who is non-white. It's interesting, actually, there was a big case, I'm blanking on the name of it, but a white man wanted to sell his home to a Black man, and he brought this case saying, like, you are impairing my ability to sell my home by this provision, right? But this is an interesting thing, Paul, that we see over time, and part of the reason why we see the perpetuation of inequality. Inequality shapeshifts, it morphs over time. So we no longer have the explicit Jim Crow segregation signs, right? But instead, what we see again are these kind of geographies of opportunity. Wealthier communities that had never been subjected to these kind of discriminatory practices were able to build wealth. And even if they tax themselves at lower rates, they're able to generate more revenue for education than a community that has historically been had their property values repressed, right? It's not like Black people got together and said, hey, let's move to Baltimore City. And the white people said, let's move. Well, the white people did say, let's move to Baltimore County. But these practices, the law did entrench these kind of inequalities. So we see school segregation. What's interesting is after Brown v. Board in 1954, and I'll wrap this history lesson up in a second, is that once school integration began to take hold after decades really of massive resistance to it, during which we saw the emergence of charters, vouchers, ways to use public money to fund private education to maintain segregation, right? We saw these evolutions, right? We see discrimination evolve. So once integration began to take hold, then we started to see discriminatory exclusionary discipline practices, which had not happened before, right? They became another technology of pushing Black students out and maintaining segregation. So what perpetuates it? It again, inequality evolves, it shapeshifts, it takes new forms, and sometimes our laws no longer reach those forms of inequality. Last thing I want to say, I'm adding on another minute, I'm so sorry, y'all, is that sometimes we have this rhetoric, what critical race theorists call color blindness, which says that what we're dealing with in the present is removed and detached from the past. The past doesn't matter. Why? That was so long ago. Why are you even talking about slavery? What impact could that possibly have on the inequities that we see today? Well, it does. History does have an impact. It does play a role. It has crafted wealth. It has crafted narratives about who is worthy or not worthy. It has crafted inequality. So as lawyers and future lawyers, I just want to close with saying we've got to pay attention to the law and how it's constructing educational inequality.
Okay, thank you so much. So my next question is for Scott, and we have this backdrop of educational inequality that Professor George just told us about. How has state constitutional law contended with it? How is it contended with unequal education? How is it contended with inadequate education? What have successes and obstacles been? And for our audience here, if there are examples or cases that sort of represent that, that would probably be helpful too.
Right. Thank you very much. I really appreciate being included in this event. This is a really, really important topic, and I'm honored to be on stage with my four colleagues here, actually, all of whom I greatly respect. Branching or building from what Janel said about the patterns of inequality that developed largely out of housing patterns that were imposed on people. San Antonio versus Rodriguez, the case that we began discussing, involved two school districts that were right next to each other in San Antonio. One of them called Alamo Heights and one of them called Edgewood. Alamo Heights largely white, Edgewood largely people of color. Massive differences in income between those two districts, but they were right next to each other. Texas funded its school system largely based on property tax, and the amount that one would tax would yield in the neighborhood of 3 to 5 times as much money in Alamo Heights as it did in Edgewood. And so if Alamo Heights taxed itself 10% for property taxes, or 10 mils for property taxes, and Edgewood right next door taxed itself 10 mils for property taxes, Alamo Heights would end up with 3 to 5 times the amount of money as Edgewood, even though they engaged in the exact same tax effort. So the theory of San Antonio versus Rodriguez is this is an inequality that was imposed by state law and should be remedied in the same way that the inequality imposed by state law was remedied in the Brown case and the cases that followed it by an institutional order ordering the unwinding of that inequality. The Supreme Court decided that we were not going to make a federal case out of economic inequality. And so the reformers in that case were frustrated, but they went immediately, and as a matter of fact, even before San Antonio, to state constitutions and found equality provisions in those documents. So Scholars of the area of law that generally covers these cases, which we would group under the label school funding litigation or school finance litigation, generally break the history of that litigation down into 3 waves. And the first wave was the San Antonio versus Rodriguez case, which is the effort federally to find remedies under the Equal Protection Clause. The Rodriguez case ended that wave. And then the second wave, which technically began before Rodriguez, picked up where Rodriguez left off. The same reformers, the same kinds of claims, but under state constitutions, which sometimes contain equal protection clauses, like the federal document, and sometimes contain clauses that are specifically about uniformity in education, as Wisconsin's state constitution does.
Can we make a microphone switch and have you use Suzanne?
Oh, it's not on.
Here. Apparently it's not.
Okay. How about that? Oh, there we go.
Oh, yeah.
Usually I'm loud enough on my own, but we're on TV. So, all right. So as I was saying, state constitutions often contain their own equality provisions. And using those equality provisions, reformers were able to gain victories in state constitutional law cases in state Supreme Courts that they were not able to get in the United States Supreme Court. As a matter of fact, they were able to achieve the remedies in the early successful cases that they sought in the San Antonio versus Rodriguez case, namely centralization of school funding. The more school funding is centralized at the state level, the less we're going to have local inequalities based on the kinds of wealth disparities that existed between Alamo Heights and Edgewood. So those cases were initially quite successful, and I'll name Serrano versus Priest as kind of like the poster child of this success, which was a case in California that originally was decided under the federal Equal Protection Clause and then came back to the California Supreme Court after Rodriguez and was decided again the exact same way under the California uniformity provision. So reformers saw success at state level in state courts under state constitutions that they could not achieve under the federal constitution. The second wave fizzled out for a couple of reasons. Number one, like any movement to recognize a broad scale right or a broad scale set of legislative duties and entitlements to individuals, it created a backlash, particularly when those rights require additional taxation. We can expect taxpayers to potentially revolt against those rights, and they did in California. They passed Proposition 13, which greatly truncated the ability of California's government to raise taxes to pay for schools. So those sorts of revolts, along with the difficulty of litigating a financial equality claim on behalf of the districts that often most need additional funds, urban districts. The difficulty there is urban districts are often on a per pupil basis already funded at a higher level than lots of the rural districts around them and even some of the suburban districts around them because they need those additional funds. There are additional security issues. Teachers have to make more money to live in the district, et cetera, et cetera, et cetera. So often they're coming to the case already with more funds. And so it's a very difficult argument to make that educational funding is unequal on behalf of a district like that. So it made litigation on behalf of urban districts very, very difficult. So a new theory was arguably needed, and it came in a case called Rose versus Council for Better Education out of the Kentucky Supreme Court. And that theory was the theory of educational adequacy. So educational adequacy tries to capture the idea that regardless of how equal the funding of an education system might be, or the funding of a district's system might be, it may not be adequate to provide the kinds of educational resources and the kinds of educational benefits that the state constitution actually commands. And this litigation, rather than relying on, or at least relying solely on uniformity provisions or equal protection provisions, relied on the substantive quality-based terms of education clauses of state constitutions. So these are, we have 50 states and we have 50 different examples of how one might phrase a quality provision in a state constitution. Wisconsin chooses the word uniform only. In my home state of Florida, your education must be a uniform, safe, secure, high quality system of public schools. So we have everything ranging in between uniform or common and what Florida has decided to do. Right. And so the idea, the thinking behind this third wave of educational reform was we can use these quality provisions and measure the education system based on whether it has achieved this measure of quality that's mandated by the state constitution, and ask the courts to remedy inadequacies in education, which might help all districts, even ones that are well-funded, if they're not funded enough for an education or an adequate education. Kentucky's case was an easy case because Kentucky was near the bottom of every single indicator you could ask about, literacy, school safety, funding, et cetera, et cetera, et cetera. And so it was a situation where the legislature was kind of waiting around for a favorable decision, or I guess they would consider it an unfavorable decision because it would go against the state. But to the legislature, this was kind of their way of being able to raise the funds they knew they needed to raise, but also blame the court for it. Right. So Kentucky's case was very, very successful. $600 million of extra funds into the education system, and reformers in every other state looked to that and said, we can do that here. And they tried to do it where they were. And in some cases, they did have success, at least getting a declaration from the Supreme Court that the system was unconstitutional, and then kind of placing a kind of a shame-based in terrorem kind of incentive on the legislature to do something to keep the public from being embarrassed about education funding in the state. But they rarely got any sort of an order from the state Supreme Court to the legislature to actually do anything, to actually raise money or increase taxes or change the way that funds were spent. A couple of states they did. New Jersey is probably the best example there, Abbott versus state. So the Abbott case resulted in direct orders from the Supreme Court to appropriate monies in ways that were different from how they were appropriated before the case began. But the challenge there is legislatures don't always obey courts. And what do you do in that situation? The New Jersey Supreme Court has never held the New Jersey legislature in contempt, but the legislature has often dragged its feet. And that case, I have lost count at how many times it's come back. But you know, if you've studied institutional reform litigation, you know you have to come back to the court sometimes to police the remedy. And that case has been back over 40 times by my last count. So that's not really a success story in the long term. It's a success story in the short term, but not really a success story in the long term. And we've had states go lots of other different directions on that. In DeRolf versus State, there was an order that the education system was unconstitutional. That's an Ohio case. The court ordered the legislature to remake the system, and the legislature said, make us. And then the court said, no, we really meant remake the system. And the legislature said, no, we really meant make us. And they went back 3 or 4 times on that one. And the court finally said, the system's still unconstitutional. We're releasing jurisdiction. So the court blinked. In Washington, in a case called McCleary versus State, the court ordered the remaking of the education system. The legislature said, make us. And the court said, no, we really meant it. And the legislature said, no, we really meant we can't agree on this. So you're going to have to do something. So the court held the entire legislature in contempt and fined them $240,000 a day until they would comply with the order. Eventually it got settled out and the court released the fines, but we had brinksmanship in that case. So the real struggle here is we have a couple of different theories for why we can challenge the constitutionality of an education system under state constitutions, but we also have limitations to those theories. Is there another way? Is there another way of policing inequalities under state constitutions that doesn't present these broad scale problems of direct conflicts and showdowns between Supreme Courts and state legislatures? And that's what we're all thinking about today. I'll stop there for now and we can talk more about that later.
Okay, thank you so much. If you guys maybe want to swap again. So far we have our kind of backdrop. We have a backdrop of educational inequality. We have a story of state constitutions being implemented with some successes and some limitations to try to promote either equality or adequacy or both. I want to bring another component of the discussion in now, and that's the question about public funding for private and religious schools. So this is a question for Professor Eckes. What do state constitutions say about public funding for religious schools? And why is not that the end of the story? What has the U.S. Supreme Court said including in a case called Carson versus Macon, that has kind of changed the landscape of things that state courts were otherwise holding.
Great question. And thank you, Miriam, and your whole team for organizing this event. It's really great to be here and see all of you on this beautiful Friday afternoon. So thanks for coming. So there are over 30 state constitutions that include something called no aid provisions, otherwise known as, oftentimes referred to as Blaine amendments, which forbid public money or limit it in some way, public money from being used at religious schools or other religious entities in the state. So this language in the state constitution varies across states. And there have been changes over the years with the no aid provisions. For example, Louisiana repealed their no aid provision in 1974. Utah has amended their constitution to allow more leeway for funding of private religious schools, et cetera. So building off Professor George's idea of history, I'm going to just give a very quick overview of the history of Blaine amendments. So Blaine amendments were named after Representative James Blaine, who in 1875 proposed a federal constitutional amendment to have a no aid provision in the US Constitution. So where the federal version failed, several states took it upon themselves to add their own amendments to state constitutions. And again, a lot of this language will say things in so many words that they're going to limit the flow of public money or taxpayer money or state money into religious entities, including religious public or religious private schools. Many scholars have pointed out, there's been a lot of law reviews written, how these amendments originated as a way to deny public funding to Catholic schools. And Derek Black, who's been referenced, who's your colleague at University of South Carolina. Yeah. So Derek Black argues in some cases they were used as a way to keep public funds out of schools for Black students and certain immigrant communities. So modern interpretations of these no aid provisions have been used to challenge school choice initiatives and specifically voucher programs that include religious schools, okay? So there's been quite a bit of litigation at the state level, also at the federal level, and Miriam referred to the Carson v. Macon decision. So I'm gonna jump forward to that 2022 US Supreme Court decision first, and then I'll fill in some of the gaps. So the US Supreme Court has indeed in recent years limited the application of these state level no aid provisions, these no aid restrictions. So just to give you a broad overview of Carson v. Macon, this was a decision from the US Supreme Court in 2022. It was a 6-3 decision. And just to give you a little bit of background about this case, Maine is a pretty rural state and it's sparsely populated. And for many years, the state, because they didn't operate public schools in every community, every rural community across the state, they had something called a tuition program or a tuitioning program where families were given state money and they could use that money to pay for private schools. So they could use public funds to pay for private schools. You know, when you get into the details of what happened in Maine, this case arose out of Maine. It's very different than traditional voucher programs that you see here in Wisconsin or Ohio, Florida, Indiana, some of the states with more robust voucher programs. So along with that public money that could be used by families to attend private schools in their rural towns, there were state mandates related to different criteria such as curriculum. If we're going to give you the public money, we want you to attend a private school that has math and science and social studies and English. And there were anti-discrimination provisions. Three families in this case took issue with the fact that this no aid provision, which in the Carson v. Macon decision was based on state law. The next two Supreme Court cases I'll briefly mention were provisions within state constitutions. They took issue with the fact that the schools, the private religious schools that they wanted to attend, couldn't receive money from the state because they didn't meet these different requirements. So in essence, the participating private schools really agreed to stand in place of public schools in districts where no public school option was available. Well, this ends up at the U.S. Supreme Court, and in a 6-3 decision, the court ruled that states may not prohibit families participating in school choice programs from choosing schools that provide religious instruction. The court found that to violate the free exercise clause. So kind of the big picture takeaway from Carson v. Macon is Maine may not choose to subsidize some private schools, but not others on the basis of their religious character. So that's one of the more recent cases, 2022. We always talk about this issue, I think all of us on this panel, in terms of three cases, really. So an earlier case in 2017 was the Trinity Lutheran versus Comer decision. This was a 7-2 decision. And in this case, the Supreme Court ruled that Missouri, which had a no aid provision, could not exclude a church from a state grant program that gave public money to a church that operated a religious preschool, a Lutheran preschool. They couldn't receive money from the state grant program. The state grant program allowed schools to resurface their playgrounds to make them safer. And the state constitutional provision, which said no money shall be taken from the treasury directly or indirectly in aid of any church, kind of stop that state grant program from being able to fund this this church, the rehab of the playground. The Supreme Court ruled that Missouri could not exclude a church from a state grant program for playground resurfacing simply because of its religious status. And then just a few years later, in 2020, there was a 5-4 U.S. Supreme Court decision, Espinosa versus Montana Department of Revenue. And this case extended the Trinity Lutheran holding that Montana violated the free exercise clause by excluding religious schools from a tax credit scholarship program for parents. The program provided scholarships for children to attend private schools, but didn't allow the money to go to private religious schools, again, because of Montana's no aid provision, which was a part of their state constitution. So there are three cases that we talk about when we're looking at these no aid provisions and how it applies to voucher programs or voucher-like programs, tuition programs. And now there's a really interesting thing that we're following, or some of us are following. Preston and Julie and I have written on this a few times, of some of the subsequent litigation that kind of naturally comes after Carson v. Macon, and it relates to whether a state has the right to have an anti-discrimination law in place that would say if you are going to accept the public money at the private religious school, can the state require you have to admit students with disabilities, or you have to, treat students in the same way you would in a traditional public school, and not discriminate, let's say, against LGBTQ plus families and students. So that's really the next wave of litigation. We already see some federal court opinions brewing in Vermont, Colorado, and elsewhere. But I'll leave it at that because I know Preston has some related things.
Yeah, thank you so much for that. So to round out our overview here, we will turn to Professor Green to talk about charter schools. So can you tell us, I mean, maybe to start with, can you tell us what is a charter school? And then can you tell us
dear.
what are some of the legal conflicts
Right.
and what do state constitutions suggest?
Well, thank you so much for having me. And this is really exciting to talk about these important issues. I must say that I get very excited right now. And when I get excited, I cough. So, these things. So I'm going to try to be zen and really, stay in the moment as I talk about this. But charter schools are defined as public schools that are created by a charter between an authorizer and the developer of the school. And charter schools, even though they're defined as public schools, they have a lot of, you know, they they have a lot of freedom from many rules and regulations that apply to traditional public schools. And they're also operated, they're also privately run in many cases by nonprofit corporations. But in exchange for this freedom, they are held to standards set in the charter. And then the failure to meet those standards could result in the closing or the non-renewal of the school. Now, much of litigation that surrounds charter schools is this public-private, um, you know, murkiness in that even though they are defined as public schools, they have these private characteristics. So I've written a lot with many people in this room about this very issue, basically saying that charter schools want to have it both ways, where they will argue that they're public for the things that they really like funding, that good old money, right? But private for those things that they may not like student rights or those pesky fiscal regulations that they want to have rules that apply to private institutions. So this then brings us then to the moment we are in right now, which is that persons who are very supportive of vouchers and funding of religious education notice this murkiness and they say, you know what, we can use that argument to get religious funding. Because if charter schools are private for religion matters, then we will be able to get funding for them and then they can be religious. So for you 1Ls out there, this involves the state action doctrine. And the state action doctrine refers to the concept that governmental entities have to follow the Constitution while private entities do not. And so the argument that many of these supporters of this expansion are saying is that, well, charter schools are operated by these nonprofit organizations. And so therefore, they're not public. And because they're not public, then it follows then under the Carson case, which Dr. Eckes alluded to, that if they're not public, then they're kind of like a voucher, right? So if they're not public, then under Carson, then you cannot prevent a religious entity from running a charter school and then running that charter school as a religious school. And Justice Breyer, in his dissent in Carson, said, this might be coming, so be aware about this. And he was right, because a few years later, in Oklahoma, there was a charter school that was proposed that would have been an online charter school that would be run by two local dioceses in two Catholic dioceses, and this school would be teaching Catholic faith, right? And everybody was surprised that, wow, is this going to really happen? But an Oklahoma agency ruled for the charters, decided that charter school could open and run as a religious school, citing Carson. And then this case was then challenged by the state attorney general, and this was found in favor of found that this school should not be open because state statutes and constitutional law require that charter schools be public, right? So this case then eventually went to the Supreme Court, and many of us thought that there was a good chance that the court might find in favor of the charter school. But Justice Amy Coney Barrett decided to recuse herself. She was very close colleagues with the person who's Nicole Garnett, who's really helping to develop these ideas. And because she recused herself, the case was decided 4-4, meaning that the lower court decision stood. Many of us think that if this case ever comes up again, and it will, that there's a very good chance that the Supreme Court is going to find that in a way that would mandate religious charter schools. That there's and this would have major impact both not just in red states, but in blue states, because many of these state laws have charter schools operated by nonprofit organizations. They can all point to all of these private aspects of charter schools to argue that they should be private and therefore should be religious under Carson. So this brings me to the second question, which is, what do state constitutions suggest about the promise or limits of charter schools? Now, I think a lot of people have been focusing on, and I have as well, on this question about religion in charter schools and about this expansion in terms of the curriculum. But I also think that people should be paying attention to the school finance implications. And that is that, the Supreme Court cases on religion really served as a school finance stopper, that it prevented this expansion. And now those cases are no longer really there. And so therefore, and this is coming at a moment where we have, low, birth rate declines, we have birth rate declines and also funding concerns. And now you also have this competition between vouchers and charters, which are already sort of, expanding, they're expanding and may soon expand and even be turbocharged if what we think may happen happens. So the question becomes, what can be done under state constitutions? But what was mentioned at the beginning of this session was that, all state constitutions, do have education provisions. And I think that we can argue that there is a duty, an affirmative duty, to make sure that you have education be provided everywhere. Now, why is that important? It's because if you have this competition, there are going to be places where there may not be that opportunity for education. Those of you in Wisconsin, where might that place be? What types of school districts might that be? Not Milwaukee, right? Not Milwaukee, rural school districts. Think about this. You have many, many rural school districts that are very, very small, and they're very, very sparse, right? And if you have this competition, all you need is just a few students to leave before these schools may have to close. And we already are seeing this nationally. And so what needs to happen under state constitutions is that we start, I think, taking very seriously the need to make sure that we actually make sure that there's a public school option in these rural areas. And I'll give a shout out to something that Dr. Mead and I have been working on, along with Chris Saldana, that talks about under state constitutional law actually designating certain sparsely populated rural school districts as education preserves, whereby you would not have vouchers and charters, in those areas where we can show that there may not be the ability to operate because of this competition, that you either dramatically limit or not allow charter and voucher growth in those areas. And I say this because in this moment that we are in right now, this is all about resource allocation, and that we need to be thinking in state constitutions about ways to make sure that we have those options everywhere where they are mandated by state constitutions.
Okay, thank you so much. So I I want to remind everyone that you have index cards available, or if you're on Zoom, you have the Q&A function to pose questions. We will have people coming around to collect those. While I wait for your questions, I'll ask one of my own. So this is a question for everyone on the panel, and we'll try to keep the answers relatively brief so that we can get to the audience questions as well. But my question is about how each of you would solve the problems that you see in education today. I understand that might be a longer answer than we have time for, so the condensed version. So the question is, what paths forward would each of you recommend if they were possible? Is it that we just need more total dollars devoted to education? Is it that we need a different distribution of those dollars? Is the problem the way that school districts are drawn with attendance zones that are fixed by neighborhood and linked with income? So if you had the power, how would you address the shortcomings you see in our education system? And if you want, we can just go down the line, starting with Scott.
Steal Suzanne's microphone here. That's a very big question. I'll focus it on the thing I talked about, litigation. Okay, so the idea that I've advanced in this area is thinking historically again about how this litigation developed. It began with Brown. It began with the cases enforcing Brown, which all included institutional or systemic remedies. And naturally, and I would say that due to basically path dependence, reformers have sought those same sorts of remedies in state courts, either large-scale injunctions, and where that's not possible due to separation of powers, declaratory relief declaring the state system of education in total to be unconstitutional. I suggest that maybe reformers think about bringing these claims as individual rights claims rather than systemic duty claims. And the reason I think that is because if you read state constitutional decisions on school funding, few to none of them actually recognize anything that we would consider to be an individual right. All of them recognize legislative duties or what we might think of as collective rights in the correlative sense. Those present the sorts of separation of powers problems, the sorts of interminable conflicts between legislatures and courts that have stalled school funding reform through litigation. My thought is that bringing these claims as individual rights claims both crystallizes the idea that one has a right to an education under one's state constitution, and also presents the possibility of moving the ball forward incrementally rather than trying to make broad scale decisions of what the state constitution means for all time and all people. I think in that sense, we might actually get more progress than we've had so far.
So I will also narrow my response to the topic that I covered. So I ended my discussion on the 3 U.S. Supreme Court decisions. And then I noted that maybe a new line of litigation will be these state anti-discrimination laws that some states have enacted that would prohibit schools that accept, private religious schools that accept public money, to not be able to discriminate against students with disabilities, English learners, LGBTQ plus student. Julie Mead and I did a study several years ago where we looked at every state statute and found not really any state statute voucher state statute comprehensively discusses this idea in their anti-discrimination provisions. You find them in the charter school laws, but not in the voucher laws. Since we wrote that paper, there have been some states like Maine and Colorado and a few others, Maryland, that have enacted anti-discrimination provisions. So I think comprehensive statutes that provide protections if you're accepting millions of dollars of public funds at your private school, private religious school, that would be something to consider. And there is just not a lot of Supreme Court precedent on this topic. There's a 1983 case that some people refer to. It's the Bob Jones University versus United States case from 1983 that dealt with private religious schools, both at the higher education level and the K-12 level. Bob Jones University, as well as Goldsboro Christian Academy, which is a K-12 school. And in that case, it was a case about withholding their tax exempt status because they discriminated against students on the basis of race. So, you know, there's debate if that would even apply to these private religious schools that are discriminating, whether it's based on disability or LGBTQ plus status. In the Bob Jones University case, you know, the Supreme Court found that it was absolutely contrary to US public policy to allow that type of discrimination on the basis of race, even in a private religious school, both again, K-12 and higher ed. So I think it's an interesting area to watch develop.
That is such a big question. My goodness. So many things. So my students are always surprised to learn that the federal government only funds roughly 8 to 9% of all education. It's significant funding, like Title I for districts serving students from low-income families, a very important funding, but it's not the bulk of education funding. So I do think there is room for an increased federal funding role. That said, um, we have to acknowledge the harm that our education system has inflicted on a lot of children. Brown versus Board of Education, a lot of people don't think about that as a school funding case, but in many ways, Brown was about school resources. It was about equalizing resources. Yes, there was strong social science research about the benefits of intergroup contact and integration, but Charles Hamilton Houston and Thurgood Marshall did tours of Southern schools, and they found how profoundly under-resourced they were. Segregation is subordinating. That's the point of segregation. If segregation was just about racial separation, Plessy versus Ferguson, separate but equal would have just been, right? As long as we're apart. The whole point of segregation is subordination. There's this horrible saying that Derek Bell, late Harvard Law professor who litigated for LDF, says that that the litigators consider green follows white. There was no way they could get in these, the cases that were consolidated to become Brown had been in litigation for years, and they couldn't get the states to comply and provide funding to the majority Black schools. So they did, it was a tactic to push for integration. Now, the way that the Brown ruling was implemented, not the Brown ruling itself, I'm not saying that it came out the wrong way or it certainly didn't, but it was implemented in a limited way in that it looked at the injury of segregation as solvable solely by integration, and it didn't really contemplate the full breadth of the injury. So I do think we need some kind of form of education reparations. And if the R word scares you, I will say that Professor Green has written an article about about education reparations. So I do think we need that. I think we need targeted, sustained funding for those districts that have been historically underfunded to repair the harm, because it's cumulative harm. And to the point made earlier, a lot of segregated, under-resourced districts need more money, not less money, to address the effects of concentrated poverty. And these effects are intergenerational.
So in this moment, I think that what I would like to see is that we conceptually, because I've said that this is now about resource allocation and sharing, and that is that we conceptually think about, like, in terms of funding and so on, conceptually think about this as prioritizing public education as a duty under state constitutions, while making sure that once you've done that as a first order duty, you then have these other possible options. And so I think that, so I've been recently saying that the way to think about that then is that you need kind of like a sort of conceptual process that would enable you to do that. And I'm becoming more and more to thinking that you have to approach this as a natural resource law problem. And that is that you have to think, and natural resources law calls for this balance between public and private interests. And this thinking about public and private interests would enable you then to think about this problem in terms of localized issues, in that like the issues that may come for a rural area may be very different from the sorts of issues that may come from an urban area. So while the education preserves idea that we are, or that talk about in this law review, comes from this idea of sanctuaries, from state hunting law and so on, and that there are other areas, right, that for urban areas that you may take ideas from zoning law that are used to protect natural resources. So this would give us the flexibility to design ideas based on particularized contexts. So I think what I'm calling for is more nuanced ideas for the moment we are in right now, which is providing for this sort of competition for resources. We need to have a concepts that will enable us to do this and balance it the right way.
Okay, thank you all. So we have a lot of questions. I do just want to remind you that we do have a reception after, so if we don't get through all of them, we'll have some additional opportunities. I'll actually start with a question that came from a couple different index cards that is a direct follow-up to Professor Green's theory about education preserves. So the people posing this question want to know, is that an equal protection violation if you're treating those districts differently by limiting their options?
No. No, because equal protection basically requires equal protection is differential treatment. And, differential treatment, you have different classifications. And this classification does not involve anything that requires heightened scrutiny. We're talking about just areas, local areas, and that's rational basis. And I think that even if you were to even try to bring a hybrid case in there, with free exercise clause and equal protection, I don't think you can win on that.
Okay. Anyone else want to chime in on the idea of education preserves before we move on? No? Okay. We're 3 minutes early, but this is the exciting moment, because if I wait too long till the next question, it'll be too late to announce the CLE passcode. So for those of you watching at home, your CLE passcode today is school. Again, today's CLE passcode is school. That is spelled SCHOOL. It is not case sensitive. You can capitalize or not. So today's CLE passcode is school. I will also say it one more time at the end. Okay, our next question, I'm going to try to blend and combine some of these both online and in person, is, I think, at least in the first instance, a question for Scott. People watching this program are based in different states, and they're wondering if their state education system is inadequate. So maybe a way to combine some of these questions would be to ask you in a more general sense, looking at sort of the range of cases that have succeeded and failed, what do you see as some of the markers of a strong case and some of the markers of cases that have not succeeded? What do people need to show other than dissatisfaction?
I'm going to disappoint everybody with this answer, and I'm sorry, I can't help it. There are very few ways of drawing systemic trends in successes and losses in these cases. Multiple people have tried, including myself, and every single time we have failed. My own study came out with a coefficient of 0.0. If you're familiar with statistical research, that's not a good one. I studied separation of powers clauses in state constitutions. Other people have studied the strength or the weakness of the substantive terms in the education article, whether we say high quality there, whether we say uniform or thorough and efficient, et cetera, et cetera, et cetera. One scholar classified them all into categories, category 1 through category 4, and then other scholars followed that scholar and tried to figure out whether those categories made any difference. No, none of the legal stuff makes any difference in terms of a predictive way. I mean, maybe they made a difference in an individual case because a court thought the clause was meaningful, but in any systemic analysis of the cases, none of the legal stuff actually matters. So then we put our legal realist hat on and say, does any of the other stuff matter? Does it matter the political community of the state? Does it matter the overall wealth of the state? Does it matter whether the state is dominated by Republicans or Democrats? Does it matter whether the state has had successful school funding cases in the past? And it turns out none of that stuff matters either. So what makes a strong case? I've been advising cause lawyers here and there throughout this last couple of decades I've been working on this. And I've suggested to them that what they need to frame up, what the successful cases have always framed up, are the kinds of resource deprivations that will viscerally affect people when they hear about them publicly. So in Kentucky, that was rats running around, no floors in some of the schools, and no bathrooms with running water. So do we have schools that still resemble that today? Yes, sadly we do. We don't have as many as we used to. So I think a friend of Preston and mine, Bruce Baker, has suggested that that maybe is a reason to think school funding litigation on a systemic basis is probably a good thing on balance, because resources overall have kind of come up if we look at things in the aggregate. But we do still have those dramatic resource deprivations, those savage inequalities, as Jonathan Kozol said famously so long ago. The cases that generally point those out and put those at the center tend to get the public's attention. And when you get the public's attention, you get the court's attention. Usually, state court judges are often elected. That makes a big difference, I think, in terms of how the case plays. The other thing is, your case isn't always about convincing the court. Sometimes it's about convincing the legislature and convincing the public. That's another defense for how we bring these cases, why we bring these cases in the face of recent failures, getting the issue out into the public in a way that viscerally affects the way they think about the education system can achieve a victory that maybe will not be a legal victory, but is still a policy victory. And so thinking about it in those terms, along with considering maybe my idea of bringing individual rights claims, would be what I would suggest.
Thank you. Okay, I think we have time for a couple more questions before we end at 4:15. I want to ask a question that I've gotten a few different ways and that I am wondering about as well, which is, what do you all think about the role of state courts in the sort of in the quality and equality of education today? Should state courts be thought of as sort of a last resort? Are they realistic protectors of education rights? Scott talked a little bit about some of the tensions between courts and legislatures and the need to go back again and again to get rulings enforced. So, in law school, we often think first and foremost about courts, but is that wrong? Are we putting too much emphasis on what state courts can do? And maybe this time we can start with Janel.
Of course, we start with me in this, as I'm thinking, no, I'm kidding. So I'm actually what's called a legislative lawyer. Now, when I was here in Wisconsin, I had no idea what a legislative lawyer was or what a legislative lawyer did. I didn't know that I would go and work for a senator as legislative counsel, but that's what I am. I do think the courts are important, but I think that also leveraging the legislative process is really important, because so you get these groundbreaking court decisions and the legislature chooses to not fund it. And again, that's no matter the makeup of the legislature. I mean, New York failed to fund their full funding formula for years, right? So I do think that we have to look outside the courts. I do think the courts are important, but they're not the last stop. And so I do think we have to look at legislation. We have to look at elevating the importance of public education as a public good. I'm actually curious, just a show of hands, how many folks attended public school? Wow, right? So, okay. Why are people devaluing public school? And by that I say, by what I mean when I say that is, you all have heard the concept of money follows a child. So that basically means that if you have a student and a public system is funded on a per pupil basis, if that child leaves and goes to a private school, they get a voucher, which in some ways is just a partial scholarship. Their family may still have to come up with some funding for that. They leave, their per pupil funding goes with them. And so that means there's less funding for the kids left back in that public school. And so when there's more investment in privatization or these other mechanisms that take students out of the public school system, there's less funding for public education. And so one worry of mine is that we will, and I know I'm supposed to be thinking of solutions, right? But one worry of mine is that public schools will just be left for those from the lowest income with the disabilities that private schools won't or can't address or serve. And to me, that is undermining the public good that public education actually is. And so that's why I do think that these funding mechanisms, these funding schemes matter.
I'm next. Okay. Yeah, I think I yeah, I've had some conversations about this with Julie and some other people thinking about this very question about the role of courts. And I think that, I mean, certainly courts can help in part because they provide this attention to the issue, right? When you have when you have litigation, that brings a lot of attention. I've also been thinking about this in terms of legislation as well. But I think that we also have to do a better job in terms of providing ways for courts to deal with this by kind of defining the terms a little more narrowly in a way that a court could then address. And Scott's been talking a lot about this. And I think that, you know, I think many of us are coming around to this as well, that we have to, and Derek Black wrote an article in Cornell Law Review back in 2018, and Julie's written about this as well, like talking about ways of just identifying specific areas that may be affected by, by some of these policies. And if we can then do that, and then do this in a discrete manner, and define that universe in such a way, then courts can then step in and do this. So I think part of that, in order for courts to be effective, is that we have to be doing a much better job of giving them something that doesn't make them think that they're like overturning everything, but being able to do this in areas where they feel that they can, you know, do it in a way that they can see some results.
Okay, I'm going to try to squeeze in one last question. We have 3 minutes. This time I might start with Suzanne. I've gotten a couple questions about, and maybe this will allow us to end on an optimistic, positive note about what things people can do. So that's applicable both to the law students in the room and the 1Ls who are interested in education and improving our education system and want to know what classes should they take, what internships should they take, what job paths should they pursue. And also for some folks watching who are not lawyers and want to know, what should I be advocating for? What should I be supporting? So where would you start them all?
So I am a big advocate, and I've written a few articles on the importance of basic legal literacy. You know, you hear someone just wrote a book that's getting a lot of attention right now on economic literacy. I believe we need more legal literacy around education issues. It doesn't need to be a law degree. It doesn't need to be one of our education law courses, but to just have a basic understanding of constitutional amendments, major cases, legislation, and how that impacts families, students, the community at large, to be able to have this basic legal understanding, this legal literacy, to be able to advocate for yourself, to advocate for public school students, all students really, and to just really inform others around you of, here's the status of the law, here's proposed legislation, here's what we can do to organize to address many of these issues that we've discussed on the panel, whether it's related to funding or voucher programs in general.
Thank you. Janel?
So one thing I would say is actually be curious and interrogate the law a little bit further. So I had actually my property professor here at Wisconsin, Professor Church, who every case, he did not teach what we call black letter law, where it's like, this is the law, et cetera. He would always say, well, what was the policy behind the court's decision? Why did the court come out the way that it did? What was the social and political context? So get curious. Again, we talked about the origins of some of the laws and policies that unfortunately may perpetuate educational inequality, but get curious about the things that you see. I always ask my students at the beginning of the semester, to tell their own education stories, to think about the schools that they attended, right? And to start to look back, what laws or policies contributed to your educational experience. Again, these inequities are not organic, they're by design. So I think it's really important as a law student, later as a lawyer, don't just take things at their face value, peel back the layers. What policies are contributing to these things? And really start to question and interrogate that.
I would say that one thing that I've found is that everything that you're covering in law school, you can find something in education. And so, you know, that's something that, so I think that's something that as you're thinking about this, trust me, I never thought, I mean, I go like, why didn't I take environmental law? You know, because now I'm like learning that now, 30 years later. There is, I mean, everything that you're learning will have some aspect of education and it will be very useful. So piggybacking on what Professor George has said, just, you know, be curious, be interested, and think about what's happening in the news because all the things that you're learning right now, there is something happening in education and it's on the 6 o'clock news as well.
Scott, final word?
I'll just say this one. It's this one.
No, is that on either?
All right, try that one. I was going to say something very quickly. Learn about your state constitution. I don't know if this class has a course in state constitutional law. If it does, take it. Great. Oh, you teach it that. Learn about your state constitution. Federal constitutional law is wholesale civics. State constitutional law is retail civics. Learn about both of them. Otherwise, you won't fully understand civics.
Wonderful. Okay, so we are out of time. So this concludes our discussion. Thank you again to all of you for attending in person and tuning in. We hope to see you at our next event, which is on October 3rd on money, politics, and the First Amendment. I will one more time remind you that today's CLE password is school and case does not matter. And a reminder to those of you who are in the room to stick around for refreshments and conversation after. Thanks so much. See you next time.